Welcome to This Explainer. Today, we're setting off on a bit of a legal detective journey into a corner of the real estate and foreclosure world that is absolutely vital, yet honestly deeply misunderstood. We're decoding the paper trail of mortgage assignments. Now, if you've ever stared at property records and felt completely lost in the jargon, don't worry, you are in the exact right place. We're going to break this all down logically, step by step, and equip you with the tools you need to truly understand what you're looking at.
All right, right off the bat, we've got to address the elephant in the room. If you spend any time at all on the internet looking into foreclosure defense or real estate law, you've definitely seen this question. Does a missing or late assignment mean you literally get a free house? It is a wildly popular internet myth. You see, when it comes to assignments, people usually fall into two camps. Some ignore assignments entirely, thinking they just don't matter, while others turn them into absolute mythology, believing a single missing piece of paper magically erases a massive debt. While both of those extremes are completely wrong. Assignments absolutely matter, but they have to be analyzed the right way.
So, here's our roadmap for today to dismantle those myths. First, the stakes and the basics. Second, separating the clues. Third, the investigative toolkit. Fourth, why timing is everything. And finally, debunking false leads. Let's jump right in.
Kicking things off with Section 1, the stakes and the basics.
So why do assignments even matter in the first place? Well, they reveal exactly who's claiming an interest in a mortgage, a deed of trust, servicing rights, or the loan itself. When things go sideways, assignments raise fundamental legal questions about standing, public record notice, and the actual authority of a trustee or a bank to take action. At its core, an assignment in a mortgage loan context is simply a transfer of a right, claim, interest, or obligation from one party to another. The party transferring the interest is the assignor, and the party receiving it is the assignee. You might see a recorded document that says ABC Bank hereby assigns to XYZ Trust all beneficial interest. But here is the absolute critical takeaway. A recorded assignment transfers an interest, and sure, it provides public notice, but it does not automatically prove enforcement authority. It's a piece of the puzzle, not the whole picture.
Moving right along to Section 2, separating the clues.
Now, as legal investigators, our first big job is untangling overlapping terms. Property records are literally full of concepts that sound super similar but operate under completely different areas of law. For instance, transferring a mortgage is not always the exact same thing as transferring the note. Think about the mortgage or the deed of trust. That's your security instrument. It's the actual lien on the property. The promissory note, on the other hand, is the actual promise to pay the debt. A mortgage assignment might transfer the security interest, and yeah, that assignment often shows up in county land records. But the note? The note is governed by negotiable instrument law or contract law. A transfer of the note might happen through a physical endorsement, an allonge, or a pooling agreement, and guess what? Those transfers might not appear in the public county records at all. You just can't assume a county records search tells the entire story of the note.
Let's look at another pair that trips people up all the time. A servicing transfer changes who manages the account. It changes who you send your monthly payment to, who picks up the phone when you call customer service, who handles the escrow. But a servicing transfer is not an assignment of the mortgage, and it's certainly not a transfer of loan ownership. The investor, the actual owner of the loan, might stay exactly the same even if your servicer changes like 3 different times. The CFPB makes it crystal clear, while you definitely must receive notices of a servicing transfer, a new account manager does not automatically prove who owns the note.
All right, Section 3, the investigative toolkit.
If we want to do a real analysis here, we absolutely have to ditch the internet hearsay and pull the actual full-text recorded documents from the county land records. When you pull an assignment, you've got to put on your detective hat and read every single word. The index alone might just give you a date and a name, but the actual document image, that holds the essential clues. You need to verify the document title. Does it reference the original mortgage recording information perfectly? Who exactly is the assignor and assignee? What date was it signed and what date was it actually recorded? Does it mention MERS? And most importantly, look right at that signature line. What capacity did the signer actually have? Did they sign as a vice president of the bank or as an officer of a nominee? You've got to extract all of this data to see the true legal picture.
To see the whole story unfold, you've really got to map out your recorded assignment pull list into a simple chronological table. This is exactly where the patterns start to emerge. You map the document title, the assignor, the assignee, and critically, the signed date versus the recording date. Take a look at this example. Original bank assigns to current trust in January. Then, in February, current trust substitutes the trustee. Because the assignment happened before the substitution, the chronological chain of authority makes logical sense on paper. This table right here, this is your master timeline.
Which brings us to Section 4, why timing is everything.
If that table is your map, well, the timeline is your magnifying glass. The single most crucial tool in our detective's kit is comparing the dates of these assignments against the dates of foreclosure activity. Let's look at a scenario. Imagine an assignment to a bank is signed on March 1st. Then, that exact same bank files for foreclosure on March 20th. But wait, the assignment isn't actually recorded in the county land records until March 25th. Notice how the assignment was signed before the foreclosure, but recorded after it was filed?
So that timing discrepancy creates a massive legal question. Did the bank actually have standing when they filed on March 20th? Now, a late assignment doesn't automatically erase the debt, and it certainly doesn't mean you automatically win the case. Instead, it creates a question of authority, and that has to be answered by state law. Does your specific state require the assignment to be officially recorded before a foreclosure complaint is filed? Or does state law say that, hey, as long as the note was endorsed and physically held on March 20th, the bank had standing regardless of the county recording? The timing issue doesn't answer itself. It points you to the legal research you need to do.
Okay, final section, number 5, debunking false leads.
Time for a rapid-fire myth-busting sequence, putting internet forums up against rigorous legal reality. Here is a bold, super common false lead that constantly distracts amateur analysts. A MERS assignment means automatic fraud. You'll see people screaming that if Mortgage Electronic Registration Systems, or MERS, is on the paperwork, the whole thing is just a giant scam. Yeah, actually scratch that. That's just not how the law works. MERS is legally established in millions of original security instruments as a separate corporation, acting solely as a nominee for the lender. To properly analyze a MERS assignment, you don't just yell fraud. You follow the steps. You check the original deed of trust to see what exact powers it gave MERS. You analyze your specific state's case law regarding MERS's authority to assign. You verify if the person who signed was an authorized MERS certifying officer. MERS assignments require document-specific and jurisdiction-specific analysis, not wild conspiracy theories.
Let's look at another really extreme myth. No recorded assignment means the mortgage is void. The assumption here is that if you march down to the county recorder's office and find a gap in the paper trail, boom, the bank has no power and the house is yours free and clear. That is completely wrong.
In actual legal reality, a missing or defective assignment definitely creates a question, but assuming it voids the mortgage completely ignores the nuances of commercial and contract law. A missing piece of paper in the county records does not automatically defeat enforcement. For example, under the Uniform Commercial Code, the UCC, Section 3301 clearly defines a person entitled to enforce a promissory note, and those enforcement rights can exist entirely independently of what's recorded in the county. On top of that, if an assignment has a defect, like, say, a wrong property address or an unauthorized signer, the remedy depends on whether state law considers that defect void, meaning it had no legal effect from day one, or merely voidable, meaning it's perfectly valid until it's formally challenged.
And here's our final, highly technical myth. A securitized trust closing date automatically voids every assignment that happens after that date. In this scenario, people tend to treat the concept of securitization like it's literally magic, believing that if an assignment to a Wall Street trust violates the trust's own pooling and servicing agreement, well, the borrower just gets off the hook.
Once again, we've got to look at the actual legal mechanics. You have to review the trust documents and apply state trust law, which is usually New York or Delaware law. But even more importantly, you must analyze standing. Courts vary wildly on whether a borrower even has standing to challenge a defect between an assigner and an assignee. A ton of courts hold that if an assignment merely violates a trust's internal terms, it's voidable, not void, and a third-party borrower simply has no legal right to enforce a contract they aren't even a party to. Don't let the sheer complexity of securitization distract you from the basic laws of standing.
Which brings us right down to the ultimate overarching standard that anchors this entire field of legal analysis. Every single time you review a timeline, an assignment, or a missing document, you've got to ask this core question. Did the party taking action have the authority required by the document and state law at the exact time the action was taken? Not, can I find a typo? Not, can I scream securitization? But did they have actual legal authority at the legally relevant time?
And honestly, that's the beauty of this work. Assignments and transfers matter immensely, but they absolutely demand discipline. They create vital questions of authority and timing, but they do not hand out automatic victories. You've now got the mindset and the toolkit to look past the myths. So as you head out to pull your own recorded documents and build your own timelines, I want to leave you with this final thought to spark your next investigation. What questions will your timeline reveal?